Hello and welcome to my show, The Legal Messages. In today's episode, I shall be taking another very important aspect of Indian Evidence Act, another very important chapter. It is about confession. This is actually described from section 24 to section 30 of the Indian Evidence Act. Basically, this word confession comes for the first time in Indian Evidence Act in section 24. And it has been described in a very detailed way in Indian Evidence Act. Apart from the Indian Evidence Act, some scholars have also tried to describe the concept of confession. For example, Mr. Justice Stephen, he has described in his book Digest of the Law of Evidence, in which he says that confession is a kind of admission made at any time by a person charged with crime, and what he does, the person makes a statement suggesting to inference that he has committed that crime. So this is broadly what Mr. Stephenson has described about in confession. That is, it's an admission by a person, and the admission is about what? The admission about his kind of confession of guilt, confession that he has acted in crime. And there has been several cases regarding this in Supreme Court. I shall be discussing some few cases in this episode about the confession. One very important case is a case between Palvinder Kaur and State of Punjab 1952, AIR 1952. In this case, the Supreme Court says that the confession or admission should either be admitted as a whole or rejected as a whole. Now, what was the purpose of saying this all? You see, when in confession, we sometimes find two parts of it. One is inculpatory, another is exculpatory. By inculpatory means an statement in which the person tries to infer that he has acted in the crime, while the exculpatory is the other way around, like he tries to hint or state about his non-participation in the crime. So the Supreme Court says that if a person makes a statement in which there is both inculpatory and exculpatory part of it, it should be taken as a whole, either should be accepted or rejected. However, in another case, it has also laid down some exception to it, and this is the case between Mohan Lal versus Ajit, AIR 1979, Supreme Court case. It says there are exceptions to it, like if there is an inculpatory evidence in the inculpatory statement in the confession, and there is an exculpatory statement as well. So if there is another proof which supports the inculpatory part of it, then that confession may be taken as inculpatory, may be taken as proved, and the other exculpatory part of it may be rejected from the same. So in different Supreme Court cases, we arrive to a point that confession is very important, and Supreme Court has laid down directions regarding it. Generally, confession is so important that it does not require corroborative evidence for the proof of guilt. However, in ordinary circumstances, in ordinary practice, what we see is that the court tries to find out some support from other evidences for the purpose of making it an absolute certain kind of situation. Now, confession is broadly of two kinds. One is judicial confession, other is extrajudicial confession. Judicial confession is a confession made before a magistrate or in court during the process of proceeding or trial, while the extrajudicial confessions are other confessions, that is other than the judicial confessions. Now, these were the basic things about confession. Coming back to now, what does different section of Indian evidence dealing with the aspect confession says? Section 24 of the Indian Evidence Act says that confession caused by inducement, threat of promise when relevant in criminal proceedings. That means if there is a confession which is made under the situation of inducement or under threat or due to promise shall not be relevant. Now, on whom is the onus to prove that? The onus to prove that the statement of the confession was made under the inducement, threat of promise lies on the accused. However, it is not necessary that he has to prove it 100% that he was made, that statement that he made was under inducement, threat of promise. He just needs to prove just needs to create kind of reasonable doubt in the mind of the court that he made this statement under inducement, threat or promise. The next section, section 25 says that confession to the police officer not to be proved. That is, if an accused make a confession before the police officer, it will not be proved. The object is to ensure that the person would not be induced by threat, coercion or force by the police, as there is general impression among the people that the police does use these things to extract confession. So the confession to the police officer not to be proved. Section 26 is also linked with 25. It says that confession by accused while in the custody of police not to be proved. That is, when the accused is in the custody of police and is making a statement to the police as a confessional statement, it shall not be proved. And there is an exception to it. If magistrate is in the immediate presence of the magistrate, if the statement of confession is made, that shall be taken as relevant in such situation. And even in cases where the person is not giving a statement to the police, he is giving a statement to some other person while in the custody of the police, that same statement of confession shall also be not taken as relevant by the court in such situation. Now the section 27 says how much information received from accused may be proved. Like in case of police custody, if a person or in presence of police officer, if a person makes a confessional statement, and on the basis of such confessional statement, if there is a discovery of sub-object related to the crime, that part of the statement which is related to the discovery of the object shall be taken as relevant. Like he says that a person says that he has committed an act of murder by pistol, and he has kept the pistol beneath the ground at a certain place, and the police, after the confessional statement, goes to that place and finds that pistol. So that part of a statement leading to the discovery of the pistol shall be taken as relevant by the court. Only that part of a statement. This is what section 27 talks about. Now section 28 says that confession made after the removal of impression of inducement, threat of promise. As we have discussed in 24, that any confession made because of inducement, threat of promise, or under inducement, threat of promise, will not be taken as relevant. Here, in cases where there is the inducement, threat of promise is no longer there, and that in that situation the person is making confessional statement, that statement shall be held as relevant statement. That is what section 28 says. Now, the section 29 is very important in a way that it talks about secrecy clause in the confessional statement. It says that confession otherwise relevant, not to become irrelevant because of promise of secrecy. That is, if a statement is made to anybody, let us understand it by an example. If a person makes a statement, confessional statement to another person, and he says to the other person that he is making this confession out of guilt, but please do not share it with anybody else. But that person with whom he has shared that statement, confessional statement, discloses it before the police or discloses it before the machinery, it will be held relevant. and it will not be held irrelevant because of the fact that it was a kind of breaking promise by the other person. Another part of the section 29 says that if a person makes a statement while in situation of intoxication, while say he was a drunk, a confessional statement made by a drunk person, and drunk person while making a statement does make confession, and during the process of trial he says that as he was drunk he was not speaking the truth. On the basis of this, it will not be held irrelevant. Just because of the fact that he was drunk, the statement will not be held irrelevant by the court. And another thing this section talks about is kind of deception practice on accused person for purpose of question. Like sometimes the state machinery does ask tricky questions on the basis of which confessional statement is made. It says that even by even making confession during this process, like a certain question is asked in a tricky way and the person makes an answer to it, which in turn becomes confessional kind of thing, which kind of bring kind of guilty of that person. So on the basis of that, the court will not make it irrelevant that just because of the fact that it was in this statement was made in the answer to a question which was a kind of tricky or deceptive question per se. The last section, section 30 of the Indian Evidence Act, regarding the confessional thing, says that confession in cases of an offense which is made by more than one person, by one person involved in that crime, that confession, which also talks about involvement of other person, shall be taken relevant by the court. For example, if there are 4 persons involved in a crime, one of them makes a confessional statement in which he says that other person Y was also involved in that crime. So while taking the statement of X as confessional statement, will take the statement regarding Y as also relevant while considering the case. So this is what generally confession is dealt in Indian Evidence Act. From section 24 to 30, you can summarize it this way, that section 24 talks about confession made under inducement, threat of promission not be relevant. Section 25 says confession made to the police officer will not be proved. Section 26 says confession made while in the custody of the police shall not be relevant. Section 27 talks about that part of a statement which is made to the police which leads to the discovery of something related with the crime, and that part of the statement will be taken as relevant. Section 28 talks about confessional statement after the removal of impression of inducement, threat of promise will be taken as relevant. Section 29 talks about confessional statement not becoming irrelevant just because of the fact that it was made under the impression, under the secrecy thing, or made under the situation of being drunk, or made in an answer to the deceptive question. And lastly, section 30 talks about confessional statement by joint offender. So these were the confessional statement, these were the provisions in the Indian Evidence Act regarding the confession and statement, and what are the relevant part of it. So hope you understood it. Thank you very much.